red button and press that to make
Ladies and gentlemen, we're just setting up for a single panel to make this a little more efficient. It'll just be a minute or two.
Test, test, test. Test, test.
If everyone would take their seats, we're about to start. The committee will come to order. We exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It is our responsibility to work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the federal bureaucracy. This is our mission. I'll now recognize myself for an opening statement. Individual freedom and personal choice are both cornerstones of our democracy and at the heart of unionization in America. However, the roles of unions have evolved from being protectorates of workers to being a powerful force in the political process. In America, what things become, they have a right to become. However, during the 2010 election cycle, unions spent more than $1.1 billion to finance political and lobbying activities. The House Committee on Oversight and Government Reform's focus of these issues will not be on the examination of the validity of unions or the right to exist, but rather an effort to ensure that the political activities of unions does not infringe on individual rights, freedoms of its workers. We are going to examine in a series of hearings the process by which union dues are collected and how transparent they are and how the money is spent. I'd like to thank our witnesses today for having the courage to stand up in public and share their stories with us and the American people. Union spending transparency. This isn't a unique word to be said in this committee. Government transparency, bank transparency, privacy issues and knowing when or how your personal information is being used. These are all part of transparency in government, a cornerstone of this committee. So today, as we look at recent court decisions that have lifted limitations on the use of dues for political spending, and I might add, lifted the limits on corporations in political spending, many workers are intentionally left unaware of their rights, and in some cases are subject to campaigns of threats and extortion. Since taking office in 2009, the Obama administration has acted to reduce union transparency and reporting requirements, particularly on what is called the LM2. Right now, union workers do not know how much of their money is being spent or funneled to super PACs like the one President Obama expressed support for yesterday. Under Citizens United, all of this is legal. Under Citizens United, all of these activities are completely constitutional and likely not to change in the foreseeable futures. But today, workers don't have a say. There is no reporting requirement that provides workers with transparency we believe they deserve. In fact, just 2 weeks after the Supreme Court ruling that paved the way for super PACs, the Obama administration began scrapping some of the disclosure requirements, particularly on international unions. In addition to weakening the reporting requirement, the Obama administration quietly scaled back on the Department of Labor's ability to conduct effective financial oversight of labor organizations and, in fact, disbanded the Division of International Union Audits. Although I can reach a conclusion that this is a union-friendly administration, that in fact this was what the unions would want, and the like, I won't reach that conclusion here today. I'll only reach a conclusion that this committee, in order to further transparency, asks, why wouldn't we reinstate greater reporting? Why wouldn't we ensure that money taken involuntarily from union members is in fact money that they have a right to know? Additionally, in the coming weeks and months, this committee will look at the other side. I pledge today to look at corporate contributions to super PACs. Citizens United is now the law of the land. We don't dispute that. But Congress has a role, particularly in ensuring greater transparency. We believe that nothing will be outside the Constitution in ensuring that the money be tracked in a way in which there is accountability for who is in fact providing great influence to the outcome of this coming year's election. But let's all realize that in the last few weeks, we've seen super PACs play a huge role in the outcome of primaries. Whether you're for one candidate, the other, or none of them, we know super PACs are here to stay. We know that they're receiving large amounts of money. And today, we're going to ask a more narrow question, which is, do workers in unionized organizations have a right to know more than they currently know about when it's being taken, what it's being used for, and whether, in fact, it has to be taken from them? With that, I recognize the book. As the ranking member is recognized, I have purchased copies of a book that I think is very noteworthy for all of us through this series of hearings, and I recommend it to all of you. It really outlines the last time, I think, that the Senate did serious work to looking at unions, not from an anti-union standpoint, but from, in fact, a friend of the unionized worker standpoint. Hopefully, it will be taken to heart by both sides of the aisle. With that, I recognize the ranking member for the opening statement.
Thank you very much, Chairman, and thank you for the book. If you read today's hearing title, you would think that it is about protecting union workers. Unfortunately, the real purpose of today's hearing is to continue the majority's unprecedented year-long attack against millions of middle-class American workers and their rights to bargain collectively for their better wages and working conditions. The majority's premise for today's hearing is that we need to conduct aggressive oversight to prevent unions from using the dues of their members to fund political activities. The majority expresses great concern and urgency over the prospect that unions are using the dues of their members to advocate on behalf of certain candidates or causes. But let's start with the facts. First, federal law already makes it clear that employment may not be conditioned on an employee's willingness to fund a union's political activities. In addition, unions may not force their members to pay for political activities they disagree with. Unions are already subject to extensive administrative procedures and reporting requirements to ensure they comply with these laws. In contrast, after the Supreme Court's decision in Citizens United, private corporations are free to spend limitless amounts of money influencing political decisions. Corporate money is flooding into American politics big time. According to statistics from the Center for Responsive Politics, the United States Chamber of Commerce, which is funded by corporate donations, spent more than $32 million on electioneering communications during the 2010 election season, about 94% of which was on behalf of Republican candidates. This unlimited corporate money bankrolls political action committees that will inject more than $200 million into the 2012 races, according to estimates. As the Wall Street Journal observed, these corporate funds constitute possibly the largest force in the 2012 campaign, aside from the presidential candidates themselves and political parties. These corporations are not subject to any of the same rules that unions face with respect to obtaining shareholder consent or input on political spending. Even if shareholders object to political spending by a corporation, they have no comparable legal rights to opt out of financing corporations' political activities or to seek reimbursement for these funds. Our colleagues on the other side of the aisle like to use rhetoric that sounds like they have the interests of workers in mind. They talk about the right to work, states and paycheck protection, but their rhetoric does not match the reality. These proposals hurt millions of American workers by driving down wages, eliminating benefits, and putting more money in the pockets of corporate execs. According to an analysis by the Economic Policy Institute, right-to-work laws lower the average incomes of workers by $1,500 a year and significantly decrease the ability of workers to obtain health insurance or pension through their jobs. This hearing is not about protecting the rights of workers. It's about further silencing the voice of unions across this country that represents millions of American workers, while at the same time encouraging private corporations to spend limitless amounts of money without transparency or accountability. If the majority were really interested in giving the American citizens a greater voice in how their money is spent on political activities, it would immediately call hearings on the proliferation of corporate spending this election season after the Supreme Court's decision in Citizens United. I am very pleased to hear the Chairman say that we will begin to, at some point, look at Citizens United and the ramifications of it, and that's very, very good news. If the committee did this on an even-handed and balanced basis, that is something I would strongly support. With that, Mr. Chairman, I yield back.
I thank the gentleman. Would the gentleman yield before you
Certainly.
yield back? I made that pledge for a reason. The fact is that the unlimited dollars are, as the gentleman said in his opening statement, on both sides. And although I don't think you can have a single panel talk about both, I know that your witness will, in fact, touch on it. And whether or not it's a minority day or in fact just a second in this series, it's my intention to look at the growing effect of super PACs. I want to make sure that I do each of them in a way that talks about the transparency. I would say to the gentleman, the one thing that I know is that you and I can't unring the bell of the Supreme Court. So the intention of this committee is to concentrate on legislation after effective hearings that mandate in law greater transparency. And I will only offer legislation after we have looked at all the elements that feed dollars into the process. And I thank the gentleman for his opening statement.
Thank you very much.
And with that, all members will have 5 legislative days to include not only their opening statements, but other insertions for the record and extraneous information. With that, we now recognize our first and only panel of witnesses. First, we go to Ms. Claire Waits. She is a school teacher in Alabama and a member of the National Education Association. Mr. Terry Bowman is an auto worker in Ypsilanti, Michigan, close to my alma mater, and a member of the United Auto Workers. Ms. Sally Coomer is a home health care worker in Duvall, Washington, and is a member of the SEIU, or Service Employees International Union. Lastly, Dr. Kenneth G. Dahlschmidt is a Willard and Management Carr Professor of Labor and Employment Law at the, is it Maurer School of Law at Indiana University in Bloomington, Indiana. And with that, if you would all rise, pursuant to the rules of the committee, all witnesses are to be sworn. Please raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give to this committee will be the truth and the whole truth and nothing but the truth? Let the record indicate all witnesses answered in the affirmative. Please have a seat. It's our practice to go down the row. It is committee practice to have opening statements be 5 minutes. I understand all of you prepared roughly 5 minutes. Your entire opening statements will be placed in the record completely, so you need not read verbatim from them if you choose not to. The only thing I will say is that as we get to 5 minutes, and you will see the indication in front of you, you will hear a quiet tapping. Please know that that is an opportunity to sum up if you haven't already. Thank you very much. With that, we recognize Ms. Waits.
I would like to thank Chairman Issa, Ranking Member Cummings, and the members of the committee for allowing me to be present today to tell my story. My name is Claire Waits, and I am a 28-year veteran teacher in Baldwin County Public School System in Baldwin County, Alabama. I am currently a member in good standing of Baldwin County Education Association, which is affiliated with Alabama Education Association and the National Education Association. I would like to share with you my experiences with the NEA Representative Assembly in the years of 2004 and 2008, of which I attended as a delegate. I would like to focus on NEA's Fund for Children in Public Education and how the name itself leads one to believe it is a charitable fund to benefit children when in fact it is a political action fund to be used to benefit the candidates of NEA's choice. In 2004, prior to attending my first representative assembly, during a required meeting of the local BCEA, delegates were told by the president at the time that we were expected to donate to the NEA Fund for Children in Public Education. We were told this contribution was non-negotiable. While in Washington during the delegate assembly, all Alabama delegates were reminded daily to make their donation to the fund. Oddly enough, we were even told how to contribute. We must make 2 different payments totaling the amount of $180. In the beginning, I was puzzled why the 2 different payments had to be made and neither payments were tax deductible. I console myself by saying it was for children. Instead of making the contribution right away, I procrastinated for several days because my travel budget was tight. Every morning, the AEA president would name off one by one the counties that had already reached 100%. I soon began to fear that they would know I was the only holdout and obediently donated the money with misgiving. I console myself again that it was for children. It was not until later in the day that I found out the true nature of the fund. It was announced NEA would be endorsing John Kerry for president, and the money from the funds that were raised would be going to his campaign. I must tell you, I felt a wave of illness come over me like none I've ever felt before. Educators who were supposed to be my people had duped me into donating to a candidate I was not supporting. Once again, I attended the NEA Representative Assembly in 2008. I was strong in my resolve that I would not make the same mistake twice. I would not donate to the Children's Fund. However, I never had the chance to show my strength. The BCEA president at the time made the contribution in my name from a fund that was given to us for travel. I was furious. I told her she had no right to make a political contribution in my name under any circumstances. She replied to me by saying it was not a political contribution, it was a contribution to a children's fund. I explained to her what I had learned about the fund in 2004, and I did not want to contribute, and I wanted the money back. She replied that she did not think that I was correct in my statement, but would have to confer with an AEA state leader. Still angry over the issue, the next morning I found the AEA president and explained the contribution was made in my name without my permission and I wanted the money back. She refused. On that same day, the BCEA president and I spoke again, and she verified that the contribution would go to the Obama campaign, which was another candidate I did not support. She now told me, presumably after checking with AEA, that I would not get my money back. She also suggested that I should not insist upon the contribution being returned because the amount of the contribution had been included in our travel money. I told her I still wanted the money back. If it were returned to me, then I would return it to the BCEA. To this day, I have never received the involuntary contribution money back. Instead, I believe it was used to help elect Senator Obama, which was completely contrary to my wishes.
Thank you.
Thank
Ms.
you.
Coomer.
Mr. Chairman Issa, Ranking Member Cummings, and members of the committee, thank you so much for this opportunity that you have given me to share my testimony regarding forced unionization and the dues I'm required to pay that go toward political causes that I am opposed to. If it were not for the forced unionization of parents like me who are merely caring for their loved ones, I would not be here today. My name is Sally Coomer, and I live in Washington State near the Seattle area. My husband Tom and I are the parents of 7 children, and I've been married for 30 years. To help you understand the unique situation regarding my union membership, I would like to first share with you a picture of my daughter, Becky. Becky is 21 years of age and lives with our family. As a result of a brain injury at birth, Becky has developmental disabilities, blindness, cerebral palsy, and a seizure disorder. Due to Becky's multiple disabilities, she requires total care and support. Both my husband and I are committed to providing Becky with the love and care she needs throughout her life. Since age 18, Becky has qualified to receive assistance through the Medicaid Personal Care Program. This paid service can be provided by a family or non-family caregiver qualified through the state of Washington. In 2009, I, along with thousands of other parents and family members, providing Medicaid personal care services to our adult children or related family members, were forced to leave our agency employment and become an SEIU union member in the individual provider system. As a parent provider for Becky, I had no choice but to comply if I wanted to continue providing care for her. I soon learned that because the state did not want to make all home care workers state employees, they set up a system where the recipient would be the employer and the caregiver the employee, with the governor the employer for bargaining purposes only. This means that Becky was now my employer and I am considered her employee. This may work for the sake of unionization, but this is not a reality for Becky. This means that if she is my employer and I am her employee as well as her guardian, then really I am the employer over myself. Becky is in no position, nor does she have the understanding to be an employer or fulfill the functions of an employer or managing me as a caregiver. I feel that she and many in her situation are being exploited and used as pawns to make it possible for there to even be a bargaining relationship. Our state has more than 42,000 unionized individual providers, of which about 65 to 70% are family members providing care for a loved one. Since being a forced union member, not only have I been subject to paying union dues, but as a parent, provider, I have lost the ability to pay into the Social Security system due to the employment relationship that the state has set up for bargaining purposes. In addition, I feel like a prisoner to the union and its causes when I find that my union dues are going toward political purposes of which I greatly oppose. Most recently, I received a notice showing that my dues were being increased to support the union's Political Accountability Fund, to pay for a lawsuit and fund a campaign and initiative that would increase training for union caregivers at a price tag of $80 million over 2 years. These types of unfunded initiatives directly impact the funding and direct services of the very population the individual provider system serves, which would include my daughter. The union dues I am forced to pay fund political candidates I do not support. They fund campaigns that support initiatives that have drained the budget allocated for Becky and other Medicaid recipients. I am tired of being hounded by mailings telling me how to vote and what initiatives to support, as well as calls asking me to go to Olympia and rally for political causes that I believe to be false and misleading. We are in a sad state of affairs when as a parent, you are forced to be a union member and pay union dues to care for your own adult child with disabilities, especially knowing that your dues are going to political causes that are detrimental to the very funding that your adult child depends on. My hope would be, rather than divert millions of dollars in Medicaid funding for union dues each month, if I could ask you to try and put yourself in my situation as a parent. If Becky was your daughter and you were her voice, I am sure that you would feel the need to speak out against this kind of manipulation of Medicaid funds for the purpose of union gain. For families like ours, these funds are critical in making it possible for us to provide the long-term care that Becky needs. Caring for my daughter is not a job that needs union intervention. This is my daughter, and this is our life circumstance. Thank you.
Thank you. Dr. DeSchmidt.
Hello, Mr. Chairman. My name is Professor DeSchmidt of Indiana University. I am part of the 9% that still has a positive view of the House, and so I'm very glad to be here today, but I haven't told anybody about it.
Doctor, you're behind. It's well below 9%.
Well below 9%. I hope there's no record being made of my appearance here. But anyway, I do want to thank you. I do genuinely want to thank you to appear here today and to get a seat at the main table with the other witnesses. We're here today to discuss a very important problem in a democratic society of balancing the free speech rights of organizations like corporations and unions with the free speech rights of individuals associated with those organizations that might dissent. The problem is how to allow corporations and unions to effectively communicate their legitimate concerns with their members and with constituents and with the public and engage in political activity without unfairly requiring dissenters within these organizations to pay or support for political views they oppose. This problem, of course, was brought to a head by the Supreme Court's surprising ruling in Citizens United that corporations are people, and as a result, they can spend all of their corporate wealth on political campaigns, including supporting directly candidates. This surprising holding by the Court made investment in a corporation a political act. And government programs that encourage or require such investment is basically a coerced political activity. Although we have extensive federal law protecting the right of dissenting employees to opt out of supporting union political activity, we have no similar law to allow dissenting shareholders, including employees with pension plans, to opt out of supporting corporate political activity. This asymmetry in the treatment of employees who dissent from union activity and employees who dissent from corporate political activity is not only unfair to people who dissent to corporate activity, but also it's a detriment to our democratic government. As I've said, we already have an extensive body of federal law to protect the rights of employees who want to dissent from union political activity. Under federal law, no one can be required to join a union. No one can even be required to pay full union dues, although in a state that allows the enforcement of union security agreements between unions and employers, an employee can be required to pay an agency fee to the union to cover the cost the union incurs in representing the employee. In calculating agency fees under federal law, unions are only allowed to charge employees for the costs of negotiating and administering the collective bargaining agreement in the unit, and they are expressly prohibited from charging them for political activities such as the support of particular candidates. Unions are also required to give dissenters a Hudson notice each year containing information that adequately explains how the fee reduction for political activity was calculated, along with an opportunity of at least 30 days to challenge the amount of the reduction. And finally, no dues or fees can automatically be deducted from the employee's paycheck without the employee's affirmative agreement, regardless of what the union or the employer agree. Failure on the part of the union and the employer to follow these practices can result in prosecution by the National Labor Relations Board or a private suit by aggrieved employees in either federal court or state court. Some have argued, including some here today, I'm sure, that we need more laws to protect the interests of employees who dissent from unions. But let me remind you the words of Chief Justice Marshall in McCulloch v. Maryland, "The power to regulate is the power to destroy." And I would argue that further limitations or requirements on union activities will undermine the ability of unions to function and also interfere with the right of union supporters to express themselves in our political discourse. Some have argued for a federal right-to-work law that would prohibit union security agreements nationwide. But union security agreements are necessary under our federal law to ensure that unions have the financial support they need to perform their duties. Under federal law, not only can you not require someone to become a member, but unions have an obligation to fairly represent all people in the bargaining unit. And as a result, this creates a free rider problem where the union is obligated to provide services, but people are not obligated to pay. Union security agreements, where they are obligated to pay by the employer to pay the agency fee, solve this problem and give the union the resources it needs to perform its functions. You can imagine the trouble in trying to run a business where you had the obligation to provide services, but nobody had an obligation to pay. It would not work. Some have argued in favor of paycheck protection laws that seek to hobble union activity and speech by requiring advance written authorization from all affected members and non-members of actions. Such laws elevate the minutest interests of dissenters over the interests of the majority and violate the majority's First Amendment rights. And here I think the experience in Alabama is instructive in this regard. What we do need to do instead is to afford employees and other shareholders who dissent from corporate political activity the same rights that are currently afforded to employees who dissent from union activity. As an employee of Indiana University, the State of Indiana takes 10% of my salary and requires that I invest it in a limited number of mutual funds, none of which allow a political opt-out. I have no information on what these companies are doing with my money, although I know some of them are doing political activity that I do not agree with. And I have no opportunity to either know about it or to dissent. I thank you for your time, and I look forward to your questions.
Thank you, Doctor. Mr. Bowman.
Chairman Issa, Ranking Member Cummings, and members of this committee, first of all, thank you for giving me the privilege of testifying before you today regarding the wrongful use of union dues for political spending by labor union officials. For over 15 years now, I have been a UAW member, and I have personally observed the intimidating political activities of my union. I am pro-union, but in the context of what unions were originally created to do, and that's to represent their employees in the realms of the workplace. I am also the president and founder of a nonprofit organization called Union Conservatives. The entire reason I felt the need to start this organization was because my union was using my union dues to push a political agenda that I oppose. Now, since I started Union Conservatives, I've heard the stories of hundreds of union workers who are also tired and fed up with the political activities of their own unions. Up to 40% or more of union workers actually vote for Republican. That means almost 6 million union workers in the United States alone feel harassed and persecuted because of the political activities of their union officials. So to protect workers from the constant political abuses of their dues by their union officials, there really are only two options. The first option would be to require a combination of audits and Beck rights. A nonpartisan third party would audit all spending by the unions and all subjective educational spending or anything regarding any political activity must be omitted from the agency fee and make the Beck decision the default position for all union workers. But the second choice is really the best and only clear way to ensure that the rights of all union workers are protected, and that is to pass a national right-to-work law. This would ensure that only those workers who agree with the political activities of their unions are paying for it, and those who find the far-left political activities of their unions to be despicable would not be forced as a condition of employment to financially support those activities. So let's take a look at the first option. The Supreme Court decision called the Communication Workers of America versus Beck acknowledged that unions do not have the right to use for political purposes the dues of workers or non-members who object to those political activities. However, union workers must first resign their membership, and then they are frequently the victims of humiliation and harassment on the job for resigning their union membership. Because of this fear stops the union member from exercising their rights. Secondly, unions still use the agency fee as a means to spend money on political purposes, and it happens all the time. The first option, making each worker a Beck rights worker as the default position, would be a step in the right direction. But the agency fee still contains many activities that are deemed extremely offensive by a large number of union workers, and those union workers fear the reprisal that comes with exercising those rights. The only effective answer to this violation of workers' political freedom is to eliminate compulsory union language from the National Labor Relations Act and the Railway Labor Act. This would, in essence, establish a National Right to Work Act. Only then will union officials be held answerable and accountable to the workers for their offensive and radical left-wing political actions. Only then will union bosses have to compete for a worker's loyalty. Competition, instead of compulsion, always makes an organization stronger. I ask you to grant to the rest of the American workers what President John F. Kennedy granted to the federal workforce in Executive Order 10988, dated January 17, 1962. Quote, employees of the federal government shall have and shall be protected in the exercise of the right freely and without fear of penalty or reprisal to form, join, and assist any employee organization, or to refrain from any such activity. I also ask you to grant to the millions of union workers their First Amendment right of freedom of association, or conversely, the freedom to not associate. You know, the United States government has given labor unions the ability to trump an individual's First Amendment right and force the seizure of an individual's personal property, their wages, for simply exercising their pursuit of happiness by applying for a job. Because forced solidarity is no solidarity at all. Even prisoners in a chain gang have solidarity. Forced solidarity is nothing more than being a prisoner in chains. Only through having a complete volunteer union is there real and true solidarity. And finally, let me quote Founding Father Thomas Jefferson. To compel a man to furnish contributions of money for the propagation of opinions which he disbelieves is sinful and tyrannical. Thank you.
I thank the gentleman. I'll now recognize myself for 5 minutes. Mr. Bowman, you took away one of my lines with the Jefferson one.
I apologize.
No, it was well said. Doctor, I'm going to start with you because I just want to understand one thing. If what you say is true in practicality as it is in law, then there should be a large difference between the agency amount taken from our witnesses, if they're under that, and union dues, presuming that a large amount is spent on directly or indirectly political activity. Is that correct?
That there should be a large amount?
Well, if a large amount of the union's activities is spent, non-PAC activity particularly, is spent on political activities, including asking for more money, asking for people to go to rallies, all of that should be reduced, the amount that the free rider, if you want to use that term, pays to simply have the other negotiations. Is that correct? In other words, very simply, the political activity money is to be only spent from union dues and not from the agency under the law. That's what you said in your opening statement. Is that, you stand by that?
Yes.
Ms. Coomer, have you looked into the difference between what would happen if you asserted your Beck rights and simply, instead of paying full dues, only paid for the portion that was negotiated to help your employer be I guess it would be having your employer treat you more fairly, your daughter, right? Yeah. Have you looked into that?
I have, and actually...
Would you turn your microphone on, please? And by the way, I'm assuming that your daughter is a good employer and you know, even without the union.
She's very cooperative. I have, and the reality is that according to the bargaining agreement, that the dues that I pay, the only way that I can not pay dues, actually the amount that I pay is the same. It's not like there's a reduced fee. I have to belong to a religious organization and prove that I belong to a religious organization that prohibits me. And then I'm required, according to the bargaining agreement, to choose a non-religious organization, and the union has to approve of that. And when I choose it, and if they approve, then that equal amount goes, I can then donate that to that organization, but it has to be upon the approval of the union. And so in the end, I'm still paying the same amount of money. And then every quarter I have to show that I have taken that money and done that.
Okay, I'm going to go to each of the witnesses for their experiences before I go back to the doctor. So your experience is it's the exact same amount of money. There's no reduction to you, or in this case, to the money you use to care for your daughter. There's no reduction if you try to opt out of the union, even though the Beck decision says there should be.
This is what I have been informed of by the union.
Ms. Waite, what have you found something similar, or what has been your experience?
To opt out the union?
Yes, ma'am.
You're not forced to become a member of the union in Alabama, but most teachers are members of the union because that's the only place we can get liability insurance. Alabama is a right-to-work state, so we don't have collective bargaining power.
So if what you're saying is that you would save money in your particular case if you opted out of the union, but one of the most important parts, what you need, the insurance, is only available in Alabama. Is that one of the reasons that you can't get out?
The insurance comes from being a part of AEA and NEA, the liability insurance. And
the state of Alabama doesn't have an alternate program so that you can choose to not be a union member?
Not yet, not at this time.
Okay, so in your case, it's not the dues per se, it's something else that is essentially locked in by the union exclusivity.
Yes, sir.
Thank you. Mr. Bowman, what has been your, I went to school down in Adrian, so yeah, I looked north and there you are. So what has been your experience in the Ann Arbor, Ypsilanti area?
Well, I have not exercised my Beck rights.
You're a very proud union member, as I understand.
Yeah, I want to maintain my union membership and work within the union to get some of these, what I would call offenses, changed. So I don't know the exact percentage of what the, personally, I don't know. I have been told by many members that the agency fee tends to be anywhere from 90% on up of what regular union dues are. So I think that's a fair assessment.
Well, thank you. Doctor, my original assertion does not appear to fit at all with Mr. Bowman, who says it's 90%, and Ms. Coomer, who says it's identical. The total out of pocket, or the amount denied her ability to take care of her child or adult child, is the same. How do you answer that in light of your explanation of the Beck decision?
It would be hard to comment on particular situations.
Okay, well, let's do something. But let me just close. Let me close with a question, and then you can have as much time as the ranking member will let us have. Shouldn't there be transparency so we could determine what the appropriate number would be? Shouldn't we know how much is being spent on politics versus other stuff in light of the Beck's decision?
I think there should be transparency, and there is transparency. And actually, there is a good study by Masters, Gibney, and I'm not going to be able to pronounce it, Zaganachik, called Worker Pay Protection, Implications for Labor's Political Spending and Voice, and published in the Industrial Relations, and we can make this part of the record. And it's hard to respond to anecdotal arguments about particular cases, but at least they looked at this across all labor organizations and across major international unions, and what they found was that for all labor organizations, political spending was only 4.27% of the money that was collected.
Okay, well,
but
then you've given me an answer. Okay, you've given me an answer, and I'm sure the ranking member would agree with you. But one of the problems we have is it's hard for us to believe that it is in fact only 4% with the experiences of how active they are. But having said that, the ranking member, if without objection, will be given an additional minute. So put it in a 6. And the gentleman is recognized.
Thank you very much, Mr. Chairman. Professor, political action committees with regard to unions, what role do they play? And with regard to funds?
Am I talking now?
Yes.
Before Citizens United, neither unions or corporations were allowed to spend general funds in support of particular political candidates. And as a result, they would set up private political action committees or voluntary political action committees where they would solicit funds from their members or from the public at large. And you see this, both corporations, you would see these political action committees where all the managers would donate the maximum amount, And you'd see this in unions where members would donate money towards political action.
Now, is that voluntary?
Yes, that's completely voluntary.
And is that separate then from what Chairman Issa was just talking about as far as dues are concerned?
Yes.
Is it two separate things?
Yes, those are separate.
All right, go ahead.
Well, and they still, corporations and unions still maintain, even after Citizens United, where they're not actually required to anymore, they still maintain these separate political action committees because there's less regulation of them, right? You don't have to explain to dissenters what you spend the money on or how you spend it because they're not covered by Beck rules. And since those are private voluntary donations, it's not clear to me why they should be covered by Beck rules.
So isn't it true that in recent history, the vast majority of union political activity is funded by the voluntary PACs and not the union dues?
That's right, and that may explain some of the confusion here. In other words, if the other panel members are looking at political action committees and union spending there, that's really not part of what they would be charged for in either an association fee or union dues.
All right. Now, you talked about, you had said that there are laws that exist to protect union workers, and you were talking about protecting them from forced political contributions. So that's clear in the law, is that right?
That's very clear in the law. There is some variation. I think Ms. Coomer's case is probably governed by state law, from what I hear her describing. The federal law is what I'm most familiar with, but it sounds to me, actually, I mean, once again, I don't want to, she knows her situation better than I do. But it sounds to me, from hearing the description, that the state is her employer, not her daughter.
So corporations are not entitled, now corporations are not entitled to spend any corporate assets on political activities, even if their shareholders object. Is that right? In other words, corporations are entitled to spend whatever they want to spend.
That's correct. The corporations that I invest my 26 years or 10% of my income in could take all of that and spend it on political purposes. I would never even know about it.
In fact, a 2012 paper by Harvard professor Benjamin Sachs explains it, and I want you to listen to this quote. The problem from this perspective is rather that the asymmetric rules of opt-out rights provides corporations a legally constructed advantage over unions when it comes to political spending. And this kind of legally conferred advantage is consistent with federal campaign finance law, and in particular with that regime's insistence that unions and corporations be put on exactly the same basis insofar as their financial activities are concerned. The result is problematic, too. From the broader perspective of democratic politics, corporations undoubtedly will be the most well-funded speakers in the electoral arena, and corporations are using shareholder funds for political donations. A 2010 joint study by the Sustainable Investments Institute and the Investor Responsibility Research Center Institute found that, and I quote, nearly 60% of the largest United States companies spend shareholder money from the corporate treasury on political activities. Now that corporations can give unlimited amounts of funds to political action committees, those PACs are estimating that they will inject more than $200 million in the 2012 elections. The Wall Street Journal has observed that aside from the political candidates and the parties, these outside groups have become possibly the largest force in 2012 campaign. Professor, how does this disparity in the rules impact unions and those that impact corporations influence the democratic political process?
Well, I think first of all, I was glad to hear you have looked at Professor Sachs's article. It's an excellent article. I cited it in my own written testimony. And when you have a hearing on this in the future on the possibility of corporate dissenters, he would be an excellent witness to have. I think as he outlines it, it does make a systematic bias in favor of corporate funding. In other words, unions have all these obligations that they have to meet, and I think rightfully have to meet, but corporations have no obligations to meet. And we're talking about putting further obligations on unions. And so as a result, any time a union tries to do anything political, there's always the possibility that they could be sued or that they'll have to file another form or whatever, and it hampers their collective action and their voice. And when you look at the larger political perspective, as Professor Sachs demonstrates in his article, corporations already have the vast majority of spending on political activities, and they have access to much more money for spending on political activities. And to hamper the weaker party in this debate, but not to require reasonable notice and reasonable chance to opt out from corporations is just not fair, and it's not good for our democracy.
I see my time has expired. Mr. Chairman, I ask unanimous consent that a Politico article dated today entitled AT&T Shareholders Demand Answers, I'd ask that that be made a part of the record.
Without objection.
Thank you.
The gentleman from Arizona, Dr. Gosar, is recognized.
It's been interesting that we've been hearing the good doctor talking about all these checks and balances. But I want to ask Ms. Waits-Coomer and Mr. Bowman, you know, application is another thing. I'm a dentist impersonating a politician, so I like application and the beauties in the detail. A Hudson notice, Ms. Waits, were you ever given a Hudson notice? For your
I'm
dissension?
not familiar with what that is.
Ms. Coomer, were you ever given a Hudson notice? Mr. Bowman, how about a Hudson notice?
No.
Were you made aware of a Hudson notice?
Not to my knowledge, no. But
Ms. Coomer?
No.
Ms. Waite?
No.
So when you actually, Ms. Waits, when you were told about the Children's Fund and its name and you found out it was very deceptive, how did your inquiry go? You know, how were you satisfied from the union?
To get my money back. I was told no, that it wasn't going to happen. And it did not happen.
You were not provided any grievance or a Hudson notice?
No, sir.
You want to answer that, sir?
Yes, I do. It sounds to me like both of them are public employees who would be governed by state law, and he is not a Beck objector, so he would not get a Hudson notice. If he was a Beck objector, then he would get a Hudson notice.
So for all of your, when you're part of this union, are you apprised of everything as far as your rights as freedoms that you're entitled to, Mr. Bowman?
in the Solidarity magazine that the UAW publishes, I do believe they have a small paragraph in the magazine. I don't know if it's in every issue, but maybe once a year they publish that you do have the right to rescind and exercise Beck rights.
Has anybody done that?
I believe there are Beck rights objectors, yes. Okay.
And do you have a counselor that you can go to?
I believe you do it on your own. There's no counselor in the manufacturing facility that I work at that helps you with that process. And like I said, most people don't do it because there is ridicule and harassment that goes with exercising your Beck rights.
Now, Ms. Coomer, you know, when you're talking about what your risk is, are you familiar with what Mr. Schmidt had said, that you're mainly a state organization?
I'm not a state employee. I've been told that. I've asked that multiple times. Any of the paperwork I've received shows that I am the employee of the client, which would be my daughter. And I have contacted the union to ask them as well about that. And they have expressed the same thing, that I am the employee of the client, which is my daughter. I explained that her developmental level was that of a small child, and they were very confused by that. So I don't get the same benefits as a state employee. I'm not a subcontracted worker. I'm, according to the state of Washington, an employee of my daughter, with the governor as the employer for bargaining purposes only.
Ms. Waite, your opportunities, you know, belonging to the union. If you don't belong to the union, what's the consequences?
There are no consequences, but you're on your own as far as if you have an issue with a parent or you're being sued, you'll have to put that out of your pocket. We consider AEA in Alabama, in the beginning, more of a professional organization and not a union because we have no collective bargaining power. Most people, especially in my county, are members of AEA for that liability insurance. Without it, we would be on our own.
Yeah, but they're also still spending money on political actions, are they not?
Yes, sir. Out of our paycheck, we have what they call an A vote taken out of our paycheck every month. And when you first join AEA on the application form, in the very bottom in the fine print, it says if you don't want this A vote, you have to actually put it in writing to our county's payroll department. And I actually have checks with me from '89 and 2008 where it's still being taken out.
So that's a donation to a
It's a donation to a PAC, a vote, and it's a PAC fund.
So have you inquired as to why there's only one opportunity for liability?
I think the state of Alabama this last year, they were trying to come up with something different for teachers, and it got thrown out of the legislature, and nothing's become of it yet. But we definitely do need another option.
Has the teachers pursued that?
On our own?
Yeah.
No.
Why not?
As far as to get a carrier to handle our liability, you know, I have not pondered that, but you have given me food for thought. We have just never done it on our own.
Well, thank you. My time's up.
Recognize the gentlelady from the District of Columbia, Ms. Norton.
Thank you, Mr. Chairman. This hearing needs to be seen in its full context of what is happening in this country with respect to the right to organize. The right to organize collectively is seen the world over as one of the great human rights protections. It's in every one of the great human rights declarations, and whether you're talking about the Universal Declaration of Human Rights, the UN Global Compact's 10 principles has its principle number 3. Businesses should uphold the freedom of association and the effective recognition of the right to collective bargaining. But look at the trends we see throughout this country that come close to trying to extinguish this very right. Here in the Congress, federal employees don't even have the right to bargain for pay, and yet they are harangued as if they were the cause of every problem facing the federal government. So the majority can entitle this hearing the right to choose in protecting union workers, but this majority will never be regarded as a champion, much less a protector of workers. In the long struggle for collective bargaining rights, when those rights were achieved, we saw a trend that was very important, because that happened right out of the New Deal. As the recovery occurred, because there were unions in place, management did not get all of the fruits of the recovery, because there were unions there to bargain for some of that. And America reached its highest point, its best economy, when these unions were strong. Today, a worker essentially in this country has to take what he can get, in a huge income gap has opened up that is shameful, and all of us understand it to be so. And collective bargaining is not result-oriented. In a market economy, you have a right to bargain for your labor. And ever since the Taft-Hartley law, there have been a plethora of laws to protect the right not to join a union. No scarcity of legislation there. But today we see an effort almost to extinguish that right. In Wisconsin, the right to collective bargaining of virtually all the rights for all federal employees would have been extinguished, but the governor, Americans Are Fighting Back, has now subject to recall, along with the state senators who voted, got twice as many signatures, Ohio repealed a similar law. 800 bills in our country have been introduced essentially to do all but repeal the right to bargain collectively. We are seeing something that if it happened in virtually any other country, we would be criticizing and withdrawing funds if we gave them any money. I do want to set the record straight because Ms. Waits, you testified at length about your complaint, but I do not see in your testimony that your complaint with the FCC about your contributions, I do not see in your testimony that the FCC threw out that complaint. Don't you think you should have also testified or at least complained, maybe that's what you want to do, that you complained about it before the FEC, were represented by counsel, and yet it was not recognized and was thrown out?
Yes, ma'am. I did file a complaint, and it was thrown out. But
thank you very much. I have very little time left. I just wanted to establish that for the record. I'm not complaining that you filed. Mr. Derschmidt, I simply ask you to lay out just in clear form so that we can understand. Has the Supreme Court established procedural safeguards to protect a worker's right not to contribute to union political activities? Indeed, has it provided workers with the right to challenge the union's calculation of agency fees? I'd like you to spell that out. We need to know whether workers somehow are victims of unions or not. So would you?
Sure. I do want to clarify, and I've done this just a little bit. There are basically three different legal regimes here. There's the National Labor Relations Act, there's the Railway Labor Act, and then there's public sector employees. And actually within public sector, there's both federal and state. So there are three different legal regimes. But certainly in the federal, which is what Congress is primarily concerned, I'm sorry, in the private sector, the National Labor Relations Act and the Railway Labor Act that Congress is primarily concerned with, in the law and in its interpretations by the Supreme Court, we have a number of established rights, and I gave those in my introduction. No one can be required to join a union. No one can be required even to pay full dues, although if you are in a state that allows the enforcement of union security agreements, you can be required to pay an agency fee. In calculating those agency fees, unions are not allowed to charge members for political activities. They're only allowed to charge them for the cost of actually negotiating and enforcing the contract in the bargaining unit. Unions, if they have dissenters who don't want to be full members in the private sector under the National Labor Relations Act, unions are also required to give dissenters a Hudson notice every year where they give an accounting of their spending and they give the dissenter an opportunity to challenge the assessment of their agency fee. And also, no dues or fees can automatically be deducted from the employee's paycheck without their consent. Now, some states have emulated some of these provisions. So in some states, you would have laws similar to that. I'm not familiar with
this is the Congress, so it's the federal law and
yes.
that I'm interested in. Thank you very much.
Thank the gentlelady. We would now recognize a doctor from Tennessee, Dr. Desjardins.
Thank you, Mr. Chairman, and thank you to all the panelists for attending here today. Really, I'm going to be fairly brief. I just have a couple of questions I'm going to direct to Mrs. Waits and Mrs. Coomer, and the idea kind of came originally just from your testimony. First is kind of a question of policy. Second is more a question of curiosity, and if I was an attorney, I probably wouldn't ask the second question, but I'm a physician, so I will. The first question would be, you both had testified to the fact that you were forced to pay union dues that were given to political campaigns against your will. Were you ever consulted by the unions as to what your choice would be for the candidate, Mrs. Waits?
No, and we had to make a political contribution for the Children's Fund, and we never had a voice or a ballot or a survey on who NEA would support with that money.
Okay, Mrs. Coomers?
No, I was just informed that my union dues were going to be increased and then they listed, the different causes.
Okay, and then the second question out of curiosity, as I heard your testimony, was that the money in both your cases went to candidates you didn't support. If it had been the other way around and it was a candidate that you supported, would you have felt differently, or would you prefer that you get to make those choices on your own?
No, I wouldn't change my mind. They shouldn't make contributions in someone else's name, period, no matter which party or which affiliation.
I agree with that. I just, for my situation, I don't think it's an appropriate use of the funds.
Okay. Thank you. And I yield the balance of my time to the Chairman.
I thank the gentleman. I'll be quick here, too. Mr. Bowman, in your testimony, written testimony, you said you asked your fellow union members, do you think union officials use your regular dues on politics? And your testimony reads, without exception, everyone laughed and said, of course they do.
That is correct.
So it's commonly understood that what they're paying is being used for political activity. Now, my concern is, do they know, do you think your fellow union members are adequately informed of their rights that they have that exist for them? And if so, how are they notified of those rights?
Well, personally, I do not believe they are adequately notified. As
now,
I said,
let me just back up. You are. You've taken the time to research and figure it out, but you don't think most
Well, this is a passion of mine, so yes, I am very well aware of my BEC rights and the other rights that come with it. But in a publication, by the way, the publication of the UAW's magazine called Solidarity is full, cover to cover, basically, of union propaganda, all paid for with regular, legitimate union dues. And I believe that should be omitted from the agency fee because it is full of political propaganda. But there is a blurb in there, I don't know how often it is in the magazine, that you are able to exercise your BEC rights if you so choose. So, yeah.
Yeah, and would Ms. Waits, Ms. Coomer, would you say the same thing, that you think, would you say most of your colleagues, fellow union members, are, it would be your guess that they're not adequately informed or not well informed about their rights?
Yes, definitely.
I would have to say that that is the case. A lot of the folks that I associate with that are union members are parents like myself. And so, no, they aren't informed.
And, Doctor, you would think that that would be part of, if you're going to join a union and as we think about this law, this area of the law, doesn't it make sense for people to fully understand what their rights and privileges and rights are?
Their rights have changed recently because Citizens United actually does allow, if you are a member,
let me ask you one
your dues
specific,
can be paid,
let me ask you a specific question.
For political purposes.
In the first 2 weeks of this, and I understand this doesn't apply to the folks here, it's about federal contractors, but I'm just curious, you know, when I go out and tour a facility in our district, and one thing I notice is the employer is required to post all kinds of things, every OSHA standard. I mean, I've had contractors tell me the things they have to post, the law requires them for their employees to see. So in fact, sometimes it's so much they don't even know if their employees just forget it all. But they're required to post all this, and yet this administration, in its first 2 weeks in office, Executive Order 13496, revoked a requirement that federal contractors inform workers of their BEC rights in employment notices. Now, why would, if we want employees to know their full rights, if we want them to have the freedom to choose and know what their money is being spent on, the rights they have, why would this administration, first 2 weeks on the job, issue that kind of executive order?
I think you should ask the administration. They might have thought it was too burdensome or ineffective.
Too burdensome to let, so your testimony is it's too burdensome to let federal employees know their rights? It's
my testimony. You should ask the administration why they did it. If you want me to speculate, if you want me to speculate, I'll speculate.
No, but you said before asking the administration, you said it may
I said it after asking the administration.
You said it may be too burdensome to let people know what their rights are under the law, and this administration.
They may have thought it was ineffective.
Ineffective. Yeah. Okay. I appreciate that. Now yield to my good friend from Ohio, Mr. Kucinich.
Thank you very much, Mr. Chairman. I came back to my desk to find this copy of this book that the chair of the committee gave to all of us. A book that was written 55 years ago called The Enemy Within, that talks about an investigation in the McClellan Committee. We can't be fighting battles that are 55 years old. We can't be doing that. And I want to say for the record, my dad was a Teamster. He was a 35-year member of Local 407. He was a Teamster during the time that Jimmy Hoffa was head of the Teamsters, and he loved Jimmy Hoffa. There's a reason why Hoffa's picture, a portrait, is in the airport in Detroit, along with others, in a place of honor. And that's because he defended workers. Now, do I endorse anything that Mr. Hoffa did that was not within the law? Of course not. But we have to stop fighting battles that are 55 years old, and let's get contemporary. And I will say, with respect to Robert Kennedy, his assassination left a vacuum in American politics that still hasn't been filled. Let me tell you about ways in which unions have improved workers' lives. A constituent of mine just sent this to me, and I thought it was important enough to read it. Weekends, breaks at work, including lunch breaks, paid vacation, sick leave, Social Security, minimum wage, Civil Rights Act, Title VII, which prohibits employer discrimination, 8-hour workday, overtime pay, child labor laws, Occupational Safety and Health Act, 40-hour work week, workers' compensation, unemployment insurance, pensions, workplace safety standards and regulations, employer health care insurance, collective bargaining rights for employees, wrongful termination laws, Age Discrimination Employment Act of 1967, whistleblower protection laws, Employee Polygraph Protection Act, Veterans Employment and Training Services, compensation increases and evaluation, raises, sexual harassment laws, Americans with Disabilities Act, holiday pay, employer dental, life and vision insurance, privacy rights, pregnancy and parental leave, military leave, the right to strike, public education for children, Equal Pay Acts of 1963 and 2011, laws ending sweatshops in the United States. It's a partial list. We're talking about a movement whose basis is social and economic justice. I don't understand what this attack is going on in this country, except it's about an effort, they call it right to work. It's about an effort to create right to work for less. Right to work for less. That's what this is all about. Right to less benefits. Now, Americans might have different opinions about unions, but I want to quote from a Labor Day speech. Quote, "On this day dedicated to American working men and women, may I tell you the vision I have of a new administration and a new Congress, filled with new members dedicated to the values we honor today. Beginning in January, American workers will once again be heeded. Their needs and values will be acted upon in Washington. I will consult with representatives of organized labor on those concerns, on those matters concerning the welfare of working people of this nation. As president of my union, the Screen Actors Guild, I spent many hours with the late George Meany, whose love of this country and whose belief in a strong defense against all totalitarians is one of labor's greatest legacies." Goes on to say, "Well, I pledge to you in George Meany's memory that the voice of the American worker will once again be heeded in Washington, and that the climate of fear that he spoke of will no longer threaten workers and their families." I'd like unanimous consent to submit into the record the words of President Ronald Wilson Reagan.
Without objection.
Thank you. Now, in the time that I have left, I just have a question of Professor. We have Mr. Bowman and others stating that right-to-work laws make unions stronger, result in more businesses choosing to settle into right-to-work states. But robust studies take into account that other variables, such as cost of living differences and economic conditions, directly contradict those assertions. In fact, studies you cited in your testimony show that right-to-work laws lower wages for both union and non-union workers by an average of $1,500 per year. And those studies show that the rate of employer-sponsored health insurance is 2.6% lower. Can you explain this, Professor, how this comes to be, and isn't, in fact, right to work destructive of the economic interest of working men and women?
Yes, Representative. As you may know, Indiana just recently passed a right-to-work law, and so we have had this debate actively undertaken in our state, and I have been asked to comment on this several times, so I'm pretty well versed on this. And there have been numerous studies done. The one that I gave you, that I cited in there, the Gould, Elise, and Scherholz article, is the most conservative and probably the best done study to date on this. And you're right that it shows that workers, both union and non-union workers' wages are $1,500 lower in right-to-work states and also 3%, almost 3%, have less workers have health benefits, and almost 5% less have pensions. There actually are other studies. Marty Wolfson in Notre Dame, because it, of course, this concerns the state of Indiana, he went and compared just average compensation per non-farm worker between right-to-work states and non-right-to-work states. And he found that actually in right-to-work states, workers are paid on average $7,835 less.
My time has expired. Thank you, Mr. Chairman. I just wanted to point out this is about right to work for less.
Well, I would just say, in response to my good friend's time and comments, my dad was a union worker as well, 30 years. International Union of Electrical Workers, worked for General Motors, and voted for Ronald Reagan. And if he were here, I would bet he would say the fact that his union dues were being used to help the guy who was running against Ronald Reagan was something he didn't appreciate. So that's what this is about. This is about employees, union members, not having their money taken from them and used against the very person they may want to see in office, representing their interests, their families, their community, and, frankly, the company they work for. And so it goes both ways, Mr. Kucinich.
Would my friend yield?
I'd be happy.
Yeah, I would just like to say briefly that I think the record would show that there were, in fact, some unions who supported Ronald Reagan's candidacy, proving my point. Thank you.
Now recognize the gentleman from Pennsylvania, Mr. Kelly.
Thank you, Chairman. Let's just have some agreement on a couple of things. First of all, today's hearing is about the right to choose, protecting union workers from forced political contributions. And I don't think there's anybody at the panel that would disagree that every American has the right to say yes and the freedom to say no. Is there anybody that disagrees with that statement? Okay. All right. Because then it calls to mind the fact that, and this keeps coming up, there's a term out here called hypocrisy. The behavior of people who do things that they tell other people not to do. So we say one thing and then we do another. So we kind of pick and choose the times that we feel that what we say is appropriate for us and not appropriate for other people. And the fact that any worker, I don't care who it is, every worker in this country, every American has the right to his or her opinion and his ability to say yes or no to where their money should go. I don't think anybody should ever be forced to donate to a political campaign or a candidate. I mean, you should have the right to say where your money goes. I don't think there's any question about that. And if anybody disagrees with that, I'd love to have a rebuttal on that, because I think that's what this goes to the core of. This is about worker rights. This is about American rights. This is about what we do believe. So let me ask you, Mr. Bowman, in your testimony, you began talking about union political spending because of a story you had read in your union's newspaper.
Yes.
Can you expand on that a little bit?
Sure. Thank you for giving me that opportunity. I have always been an open political conservative inside my union, which has led to a lot of harassment and persecution. But over 13 years or so as a union member, we're told who to vote for. At our union meetings, our plant chairman points at all of us and says, "You all better be voting for Democrats." So over 13 years, you get to the point where it really becomes quite burdensome. In our local newsletter called the Raw Facts, because the plant I work at is the Rawsonville plant, there was an article in there that said, "Health care reform, what would Jesus do?" Now, I have to put this in context. I have studied at seminary, and I'm quite familiar with Scripture. And in this article, it basically made Jesus appear as if, according to Scripture, that he was, number one, a socialist, and number two, that he would approve of the Affordable Health Care Act that was in discussion at that point. I knew from my own study that they completely took it out of context, and so at that point I stood up and I said, enough. I've got to start doing something, and that's when I started getting the idea of coming up with union conservatives and organizing conservatives in the union to fight back against that.
Okay, and so tell me about the group, the union conservatives that you found. Tell me a little about that group and how that group feels and the feeling that you're getting and the number of people that are signing up on that.
Well, the majority obviously are people who are of the conservative political nature. I do have some Democrats who are signed up that say they don't necessarily believe in my political affiliation. However, they do think that all union members should have the right to speak their mind without fear of harassment and ridicule, which of course, on the assembly line, many people agree with what I agree with, but they keep their heads down because of the intimidation that goes into the union atmosphere.
So when you're speaking about that, you're speaking about actually what you experience being part of the workforce.
That is absolutely correct.
Okay, so this isn't anecdotal. This isn't something that you heard from somebody else or something you think. This is what you see on the floor every day.
This is my story.
Okay, because my experience has been the same way. Now, I'm an automobile dealer and have spent a lot of time in Lordstown with our UAW guys. In fact, we would go back and forth. We'd go to Lordstown and watch them build cars, and then they'd come to the dealership to see how that relationship worked. Because the result, it comes down to, listen, we need those guys to build great cars. And listen, I know you're a Ford guy,
right?
So, and I know you didn't take the money in the bailout, so I'm real happy about that.
Thank you for that.
But I also know that America's ability to build things has never been questioned. We build great products.
I'm a very proud automobile worker, and I am, as my testimony said, pro-union, but only in the context of what unions were created to do, and that's just to represent their employees in the realms of the workplace, not as a socioeconomic group or a quasi-political party.
Yeah, and I appreciate that, because my experience has been exactly the same. As I said earlier, my dealership is located about a half a mile away from AK Steel, and those fellows belong to the UAW also. There is not a person I've ever talked to, and it concludes on both sides of the aisle. We are so much in favor. We are all pro-worker people. We are all pro-labor. We want to see people back to work. But we also want to make sure that we protect the constitutional rights that people have under the First Amendment. You can do and say what you want when you want to say it. Nobody can inhibit you from that. And by the same token, nobody should ever force you to give money to a political candidate you do not want to give money to. And I thank you for your testimony. I yield back my time, Chairman.
The gentleman yields back. I believe that's not yet a vote, right? Good. Well, in that case, Mr. Clay, you get your full 5 minutes. The gentleman is recognized.
Mr. Chairman, and the 6 bells indicate that the House is in recess. Let me ask Ms. Coomer, how did the state of Washington inform caregivers that you were going to join SEIU, that you were going to be in a union? How was that done?
Actually, I wasn't notified that I was going to be joining the union. I was just notified that I needed to become an individual provider.
Okay, and then how did the process come about that you joined?
I did not know until I got my check and I saw that union dues had been were being deducted.
Okay. Then of course you probably inquired about where your union dues were going.
Yes.
And you said in the statement that dues go to fund candidates that you would not normally support. Have you had any contact with union officials to say, well, here's a list of candidates that I would support?
I contacted the union to find out about trying to divert my dues somewhere else and had a really hard time getting any kind of a response. They would refer me back to the bargaining agreement, which I've tried to decipher for the last year, and have not gotten a response from the union.
Do you think that that the rank and file's opinions are really adhered to or listened to by union leadership as far as how they select candidates they support?
You know, I'm not sure. All I know is that the information and materials that I get don't just have information in regards to candidates, but it also has information and encourages us to vote for certain initiatives or not vote for other initiatives or laws that, again, I don't always agree with.
Thank you for that response. And Dr. Schmidt, you had something to add?
Just to kind of try to clarify, I mean, once again, Ms. Coomer knows her situation much better than I do, but I do know a little bit about the law and what's happened in organizing this situation. And what's happened nationwide, actually, in a variety of states is home health care workers have, prior to the organization of state associations for them, they were independent contractors, and they were actually prohibited from collective bargaining. And so they would work and get compensated by the state, and they were paid very poorly. And unions thought this was a problem, and it started in California. It went on to Illinois. I believe it was in Washington, too. And what they said was, let's organize a state entity that actually employs these people. And as a result, they can be employees, and then they can collectively bargain. And I believe that's what was done in Washington, so that when she became an independent home health care worker, she was actually, I think, an employee of the state.
Doctor, I don't mean to interrupt, but please limit your hand motions. They're going out a long way.
The two clues to that are, first of all, that the union negotiates with the governor, not with her daughter. So I don't see how the daughter can actually be the employer. Also, that she's exempted from Social Security. State employees, when I was a state employee in Ohio, I was also exempted from Social Security, and that's not common for state employees, but it does happen for state employees. Now, I did want to, the representative down here, I can't see his name.
No, you look. Let's talk. Don't worry about what he said. Isn't it true that when unions get involved in the political realm, they are giving a voice to millions of working Americans on the very activities that are important to the working families whom they represent? Issues such as, for example, health care, education, labor standards, civil rights, and workplace safety.
I believe that's true. And if you look historically, I mean, we could still have child labor laws. We could still, have 60-hour work weeks. I love that little bumper sticker that says, the weekend brought to you by the labor movement.
Now, the primary responsibility of unions has been in managing the employment relationship between workers and management, correct?
Yes.
And you stated that federal law also requires that the union must fairly represent all employees in the bargaining unit, whether the employee is a member of the union or not.
Yes.
And can you explain the importance of the fair representation principle in labor management relations?
Yes. It actually goes back to our system of exclusive representation. And we have set up, under our federal labor law, we have set up bargaining units like little electoral units. We're the only people in the world to do this. Other people do it differently. But we have a bargaining unit, and over a bargaining unit, we have an election. And if a majority vote for the union, everybody is represented by the union. And if a majority does not vote for the union, nobody is represented by a union. And as a result, you can always have people that are unhappy with the choice. It's a collective decision. And we did this because we advocate democracy worldwide. And in the 1930s, we have been, I mean, you've seen that most recently. I mean, we invaded Iraq in part to bring democracy there or whatever. I mean, we are very big on democracy. And the idea was that if democracy was good for the government, it could also be good for the workplace. And so we had the idea of bringing industrial democracy to the workplace. And that actually goes to the membership, too. The representative over here asked if people should ever have to support political causes that they don't believe in. And I agree that in general, they should not. But the one qualification I would make is when you are a member of an organization, sometimes you are going to influence that organization and they will do what you want them to do. And sometimes somebody else will influence that organization and get them to do what they want you to do. If you, Mr.
Would the gentleman wrap up? We're about a minute overdue.
Okay, I'm sorry. Mr. Bowman is concerned because the organization of which he is a member does not always want to do what he wants to do. But if we said organizations can't do anything unless they get the agreement of everybody within the organization, they would never do anything. And as a result, he has the choice to either be a member, as he currently is, and sometimes not be happy, or to be a non-member, in which case they will not be able to charge him for that political activity.
I thank the gentleman. We now go to the gentleman from Illinois, Mr. Walsh, for 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for coming. Let me apologize if I'm redundant at all. Mr. Bowman, help me connect some dots here. Sure. The Obama administration, as we know, has taken actions over the last few years to strengthen union control over workers. They've done this primarily by weakening reporting requirements for those unions. These actions have combined to basically give unions the ability to spend members' dues without rank-and-file members knowing where that spending is going. We also know that the unions put about $1.4 billion into the 2010 elections. silly, stupid question, but let me ask it. Of that $1.4 billion, how do you think that money went as far as split between Republicans and Democrats? Do we know?
I do not have that figure, Representative, so I'm not sure.
What would you guess?
My guesstimate would be, again, well over 90% of the contributions would go for one particular party over another. That's correct.
And what party would that be?
That would be the Democrat Party.
And I think that's probably a pretty safe guess. Why is that? And again, silly question number two. If over 90% of that $1.4 billion is going to Democratic candidates and causes, are we to assume that 90% of union rank and file are Democrats?
Well, I know that not to be true. I think that the unions now are becoming very prominent in the public sector, the government sector, as opposed to the private sector. The Bureau of Labor Statistics released their 2011 figures last month. The private sector was at only 6.9%, I believe, of employees were in the union membership. But it was much higher, in the 30% range of union members, 36% range of union members. So the relationship between the union and their Democrat officials in the state is a cycle of dependency that's fed with taxpayer dollars. So I believe that's where that comes from. All that money is coming from taxpayer dollars.
So then it leads us to the next question, which is, again, if 90% of what union leadership is giving politically goes to Democrats, and we know that the union rank and file is not 90% Democrat, who is the Obama administration listening to then, in your estimation, union leadership or the rank and file?
Well, of course it's the union leadership.
Why would that be, though?
Well, because they control the money and control the funds.
So not necessarily the interests of the rank and file.
That is correct. And we have talked about the difference between PAC funds and forced union dues in the difference. But my written testimony has many examples in the agency fee that are very political activities, but are still included in that agency fee.
You know, one thing I've noticed a lot of the last year or so when I've been at home is union rank and file members, trades union guys, private sector union guys, are pretty upset right now. They're not working. Many are struggling financially. They're losing their homes. They're upset with their leadership because their leadership really sort of foisted this administration on them. I'm seeing a widening gulf. Do you get any sense of, is there any groundswell among rank and file who are more willing to publicly express how upset they are with what their leadership is doing?
Very much so, and that's why my organization, Union Conservatives, was started, because there are so many people who are feeling left out of the activities of the union officials and wanted to join an organization that felt actually mirrored their interests. I can give you two examples recently. The Keystone Pipeline issue, many union members are extremely upset. In fact, a labor's union, I believe, pulled out of the Blue-Green Alliance because of that, because so many jobs were, potential jobs were killed by the decision. And then also, so many union members were upset after October 2nd, 2010, when union officials rallied in Washington, D.C., called the One Nation Working Together rally. And they found out only afterward that they also rallied with the Communist Party USA, the Socialist Party USA, and the Democratic Socialists of America. And when it was reported afterward, so many union members on both sides of the aisle were very upset about it.
Final question, Mr. Chairman. Is it safe to assume, Mr. Bowman, that you see a widening gulf between union rank and file and their leadership?
Absolutely. I speak to a lot of groups. Even Tea Party groups have a lot of union members in the Tea Party groups as well.
I'll be dogged.
Yes.
Wow. Thank you. Thank you, Mr. Bowman. Thank you, Mr. Chairman.
Thank you. We now go to the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. Just as a, I guess, general disclosure, I should disclose the fact that I'm a 30-year member of the Iron Workers Union in Boston.
I'd ask unanimous consent the man be given an additional 30 seconds to explain his entire family lineage in the union movement.
No, that's okay. We'll skip that, but that's for another hearing. But I'm also a former union steward, a former union president for the Iron Workers Union. Actually worked at the UAW plant in Framingham, Massachusetts. So, Mr. Bowman, we certainly have some. I certainly have some related experience with respect to your testimony. And Ms. Coomer, the SEIU actually ran a candidate against me in the last election. So we certainly have some empathy going there. In spite of the fact that I have, a very, very strong union voting record, as you might expect. Even when I was president of the Iron Workers Union, I still strapped on a pair of work boots every day and went off to the construction site. So I wasn't a sit behind the desk president. I was an iron worker working on the job, driving a pickup truck, and in a very dangerous industry, I might add. And I was thankful every single day that I went to work that I had a union watching out for me, because as a union steward and as a union president, I had more than enough occasions to sit in an emergency room waiting for one of my co-workers to get patched up, or unfortunately I went to far too many wakes and funerals from my brothers and sisters who went out to work in the morning in a very dangerous industry and did not come home. And that is a strange, it's bizarre, it's obscene in a way, that folks go to work every day, sometimes in dangerous industries, and because of the lack of protections, they don't come home. And that's one of the greatest gifts I think that my union gave to me, was they tried their best in a very dangerous industry to make that job safe for me so that I could come home every day to my family. And I just want to make a few observations. You would think from the discussion here today that maybe 50%, 60%, 70% of today's workers are unionized. But according to the Bureau of Labor Statistics, 88% of the workers who draw a salary or a wage in this country today are non-union. We got 11.8% of the workers and salary workers and wage earners in this country. 11.8% work under a collective bargaining agreement. And it just, in fairness, this committee has really been tilted toward going after union employees. This has not been an even-handed process. I have before me a list of 16 hearings we've had here. We've had probably, let's see, out of the 16, we've had hearings on questioning the pay levels of federal employees, looking at right-sizing the federal workforce, trying to get people out the door, we had a hearing questioning the official time, whether union stewards in conducting their business, whether that was a good value for the taxpayer. We had a hearing entitled Postal Infrastructure. How much can we afford? Our postal workforce costs sustainable? Because we wanted to cut the postal workers, union workers' wages. We had a hearing on the Hatch Act, whether or not political action by public workers should be sustained.
Would the gentleman yield?
Not at this point. No, I've only got 5 minutes. So we've had, and I honestly don't believe that the employers, the corporations, are going to be brought in here. I don't believe that. We've had 16 hearings on employees and busting unions, and we've never had a hearing on. Don't hold your breath to see Goldman Sachs come through that door, because in all the time I've been here, this House, the whole House of Representatives, think about Goldman Sachs and what role they played in this country's economic crisis. Never came through that door. Not one hearing on Goldman Sachs, and yet we go after the unions on a weekly basis here. The other thing is, the last thing I want to say is about Citizens United decision. Terrible decision, probably the worst decision in my lifetime on the Supreme Court. And they equate corporations with unions. The difference with unions and corporations is that even in your case, the union's ability to garner resources is limited to passing the hat. They pass the hat among the employees. sometimes willingly, sometimes unwillingly, getting contributions, individual contributions. But if you look on the corporate side of things, you got ExxonMobil making $30 billion, AT&T making $20 billion, Chevron making $20 billion, JP Morgan $17 billion, Walmart making $16 billion, and they can take that money without shareholder approval, without disclosure to the shareholders, and use that money for political purposes. They can use the machinery of profit-making, these corporations, these massive corporations, with impunity. There's no questions being asked of them. I appreciate your indulgence, Mr. Chairman, and I yield back.
I thank the gentleman for yielding back his negative 50 seconds. I might note for the record that Mr. Waxman was very good at holding Hatch Act hearings, and you did forget to mention Governor Scott Walker, who is, in fact, an employer. And with that, we go to the gentleman from South Carolina, once an employer, I guess, of many of the members of his district attorney's office, recognized for 5 minutes.
Thank you, Mr. Chairman. I couldn't help but think when Secretary Geithner from the Treasury came that we had a glimpse of Wall Street, so I don't know whether the gentleman is counting that as a Goldman Sachs visit or not. Ms. Waits, you went through, and I tried to take notes, you went through an incident that happened with respect to the Children's Fund, and what strikes me as being tantamount to an involuntary contribution. Could you go back, just take 30 seconds to go back through that factual predicate for us one more time? What happened?
Well, in 2004, when I went to the delegate assembly, we were told right off that it was non-negotiable. We had to make a donation to the Children's Fund in 2 separate payments that amounted to $180, which I finally did, and I procrastinated because I couldn't figure out why it had to be 2 different payments, and I couldn't figure out why it wasn't tax deductible. But the name is the Children's Fund. It's the Fund for Children in Public Education, so you assume it's for children in public education.
Oh, who in the world could possibly be opposed to something called a Children's Fund?
Yeah, if you ask a teacher to give money, a teacher may have $2 in her purse, and if you ask for that $2, that teacher is going to give a child the money. That's just what we do.
Are you familiar with the work of the Children's Fund?
I was not until the last day of the assembly when they announced that the money that had been raised through the Children's Fund would go to the campaign. In 2004, it was John Kerry. In 2008, it was Obama. And that was the very last day. Now, I found out what the nature of the Children's Fund was in the women's bathroom on a break when 2 ladies from California told me. I asked them if they were required to give because you were very pressured into donating. And they said, no, it was a political fund, and that's how I originally found out about it, was from some other lady.
We may have a clip, Mr. Chairman, of an ad run by the Children's Fund. Let's see if we have one here.
What do we know about Tom Ganley? We know used car salesman Tom Ganley was sanctioned for deceptive advertising. Now he says he wants to bring jobs back from overseas. The same Tom Ganley who signed a pledge to protect tax breaks for companies who ship jobs overseas. Can't trust Tom Ganley on cars, can't trust him on jobs. We just can't trust Tom Ganley. NEA Fund for Children in Public Education is responsible for the content of this advertising.
Wow. I didn't see a word about children or education.
Yeah, if you're going to have a political fund, name it a political fund, especially when you're in an education field. People will give to children for any type of education purpose. I speculated. NEA gives teacher grants, and I originally thought, okay, maybe it'll go to teacher grants, and then I thought, well, maybe it'll go to underprivileged children or children in high poverty areas. And Children's Fund is a children's fund. It shouldn't be a political fund. And
so
that's
you
what they
didn't know it was going to go for an attack ad in
no,
a
sir.
partisan
no,
race.
Sir.
Now, something in your original opening statement led me to believe that there was not only a component of involuntariness to it, but that there was perhaps some shenanigans with travel money.
They took dues from BCEA members, and they included the amount of the donation in 2008 into our travel money, because when I kept insisting to have the money back, I was told to stop insisting because the amount was included in my travel money that was separate from my travel money, so which infuriated me even more. They used our BCEA dues to contribute.
Professor Dow Schmidt, excuse me. I was just a country prosecutor. I never got into FEC law. And is that legal, what she just described?
I am a labor and employment law professor. So
oh, but you have an idea, don't you?
Well, I would give you my opinion that I find that disturbing too, frankly. She's a state
I didn't ask whether you found it disturbing. I asked whether you found it legal or not.
That I don't have an opinion on. I don't know. I don't know that law. As I understand, she did file a complaint that was denied. She is a state employee, so she's governed by state law. So I can't tell you what the state law is on her objecting. But I think she's got a legitimate complaint there that if they put forward that fund in that way, that she should expect it to go for. It should be clear whether it's for politics or not. I suppose they could make the argument that this guy was against children somehow, and so therefore this was the best way to use that money. But I think she's got a legitimate complaint, and I'd be interested to see why her complaint was dismissed.
I'm afraid I'm out of time, Mr. Chairman.
Yeah, the gentleman is correct. His time has expired. We now go to Mr. Conley is not here. The gentleman from Illinois, Mr. Davis, is next for 5 minutes.
Thank you very much, Mr. Chairman. And while I can't say that my work was as dangerous as that of Mr. Lynch, I can say that I was a proud union delegate, member of the Chicago Teachers Union, chairman of a professional problems committee during the early days of my life when I was about 23 years old, and I enjoyed the work tremendously. I think that those of us who are concerned with unions' political advocacy should also take a good look at corporate America. According to the Center for Responsive Politics, the Chamber of Commerce, which is funded by corporate America, is one of the top sources for political spending. Harvard Law professor Benjamin Sachs commented on the Chamber's spending in a 2012 paper, and he noted that the Chamber, which is funded by corporate donations, spent more than $32 million on electioneering communications during the 2010 election season, approximately 94% of which was on behalf of Republican candidates. Professor Doss-Smith, now that corporations are free to use their general treasuries to fund political activities, would you agree that corporations have the financial capability to vastly outmatch that of individuals and unions?
Well, I think that's true, and I think that's evident in the upcoming election. The statistics that you cited from Professor Sachs' article, the 5 highest spending non-party organizations, including the Chamber of Commerce, $32 million in the 2010 elections. 4 of the 5 all supported Republican candidates.
You know, I've always believed that fair is fair. Unfortunately, it is difficult to get a handle on what the actual scope of corporate political influence really is. While there are a lot of checks on union political spending, there don't appear to be any real checks on corporate America. Federal law requires unions to file a detailed report with the Department of Labor disclosing all of their political spending. Professor, do corporations have any similar duty that you are aware of to disclose their spending for political purposes to their shareholders or to the public?
I know of no restraints like that, and they also don't have to let people opt out. And just think about how popular that would be. If you did allow an opt-out, they would have to refund a proportionate share of what they spend on politics to their shareholders. They would set up mutual funds that got these refunds, they would be dissenter mutual funds. Those mutual funds would earn more money than similarly situated mutual funds. They would be very popular. So I think there's a real demand out there for dissenters not to have their money, my savings for my pension, spent on political purposes that I oppose.
Thank you very much. And I think the Los Angeles Times article pretty much came to the same conclusion. And it said, and I'm quoting, that despite mounting calls for greater transparency, only a few of the country's 75 leading energy, healthcare, and financial services corporations fully disclose political spending. Groups such as the Chamber, some of which spend millions of dollars on elections, are not required to reveal their financial supporters, and companies are not required to report their donations to those groups. What information is publicly available suggests that substantial corporate political spending remains in the dark, leading to an incomplete and at times misleading picture of companies' efforts to influence legislation and elections. Professor, given the lack of transparency and disclosure policies and practices of some corporations, do we even know how corporations are spending shareholder funds to exercise political influence?
I don't believe we do.
Well, thank you very much, and I think it's clear that there is great disparity between what unions and individuals are able to spend and what corporate America is able to spend for influence. I thank you, Mr. Chairman, and yield back the balance of my time.
I thank the gentleman. We now go to the gentleman from Michigan, Mr. Wahlberg, who also hails from an area just south of Ypsilanti. Do you include any part of Ann Arbor in Ypsilanti?
Well, we don't include Ann Arbor as Ypsilanti, but I
always look at them as the Twin Cities. I want to make sure.
I have Ann Arbor in my district, so.
You do. Okay. Well, then, Mr. Bowman would like to talk to you.
Well, and I've had a privilege.
Recognized.
I've had a privilege of walking in the Saline Parade with Mr. Bowman, if I remember correctly, who surprised me out of my socks, as it were, that you were a UAW, proud UAW member.
Yes.
Working for a Republican candidate.
That is correct.
And it was a delight to talk with you, and I've tried to matriculate that information into my understanding since then.
I'd like to talk to you after this meeting.
Delighted to see you here,
okay,
and appreciate your testimony. I apologize for not being here for all the other testimonies, though I've had a chance during the intervening time to read them. Members of Congress aren't unionized, so our work rules don't allow us necessarily to deal with being in two places at the same time, and often we have that situation. I was a United Steelworker for a while in my life at the No. 2 Electric Furnace, Southworks U.S. Steel, south side of Chicago. Same place my dad was a union worker and helped organize union at that plant early in his career in the early 40s. The opportunity that he proudly wore his union pin, those little pins they used to wear, attached to his lunch bucket as well as his hat and his coat, and would come home with those. By the time he finished his career as a machinist, tool, and die maker, he no longer was a member of the union, worked for companies and shops that weren't unionized because he felt it went away. And it was an example was given even in my first week at U.S. Steel Southworks when I was told by the union to stop working so hard, quit sweeping underneath the furnace so hard, and find a box and crawl up and go to sleep. I understood that was not the work rules and the working condition that my dad worked for, to make sure that there was safety, that you did come home for a weekend of relaxation. I was interested to hear the statement this weekend brought to you by the labor union. But, Ms. Coomer, I'm sure that they would not go along with a statement that could be made, you too can be a union caregiver for your child, like it or not. I'm sure that would not be the situation that you would desire to see as an ad. And I applaud you for what you are doing for your child. And sadly, some of that opportunity has been taken away from you as a result of the union. But let me go back to Mr. Bowman. I've heard with some reverence talk about the Black Lake facility.
Mm-hmm.
Describe that a little bit more. You mentioned in your testimony, but describe that facility and why a lot of my union friends would talk with it with some reverence as to what goes on there and what does take place there.
Sure. Well, the UAW has a facility called the Black Lake facility in the upper lower peninsula of Michigan, almost to the Mackinac Bridge, as a matter of fact.
Beautiful area.
Beautiful grounds. It has an 18-hole golf course, quite highly rated from what I understand, all owned by the union, all paid for with regular union dues. They did this as an investment, and from what I understand, they've been trying to sell it, but have chosen not to do that because of the deduction or the loss of property value. But at the Black Lake facility, it is supposed to be a facility for education. And I use this quote mark because I have never been afforded, even after 15 years of going to the Black Lake facility, only those who are very involved in the union political side are invited to go to the Black Lake facility numerous times. And they have classes there, one-week seminars on grievance handling and the history of unions and all these different kinds of classes that are available.
Upgrading your skills as an employee and all of that.
That is correct. But unfortunately, as I have been told numerous times, people come back and say that it really is an opportunity for the union to indoctrinate on the fact that the Republican Party has been the party who has, over time, done everything against the middle class.
They wouldn't say that.
Against the working people.
They would actually say that.
They would actually use those words. Yeah, absolutely.
With your dues dollars paying for that.
And regular dues are paid for this facility. That is not subtracted from the agency fee, as is any of the publications or the salaries of the officials that engage in these activities.
Is there a publication that your dues help fund called Solidarity?
Yes, there is.
Are there any political statements in Solidarity that you would have concerns with as a union employee?
Extremely. Yes. Very often in every issue.
So your forced dues pay for Solidarity printing?
That is correct.
Against your viewpoints and 1,000 others, potentially, that you've listed today?
That is
Time has expired. The gentleman may answer.
Oh, I can't answer. Yes. And unfortunately, Solidarity Magazine, the publication and the dues, or excuse me, the wages for the union workers who put this together are not reduced from the agency fee. They consider that legitimate union purpose.
Thank you. I thank the gentleman. The gentleman from Massachusetts, Mr. Tierney, is recognized for 5 minutes.
Thank you. Doctor, let me start here. I think in this hearing we want to make sure that individual union members are not being disadvantaged inappropriately, that their rights are being protected. So I want to just walk through again. The National Labor Relations Act allows for people to organize, form a union, and then collectively bargain. Is that correct?
Yes.
And then a later amendment, I think it was about 1947, indicated that states had the right to opt to be right-to-work states.
Correct.
Then there was case law that indicated if that occurs and a contract provision is put in, people that do not want to be paying their union dues can at least make sure that if they're obligated to pay those union dues, none of it goes towards political uses. Is that correct?
That's true. The statement actually uses the term membership. It allows union security agreements that require membership. But the way the Supreme Court has interpreted that is that you can't actually require someone to join a union, and you can only require them to pay an agency fee.
Okay. So if that law is in fact enforced,
yes,
then I think that we've pretty much protected those individuals from what they would otherwise object. The question of some of these folks here might be is whether or not it was enforced properly or applied properly in their position. I think that's a case by case. I do note on Ms. Waits that when her case went to the FEC, that sort of was resolved because there seemed to be a misunderstanding between Ms. Waits, Ms. Fox, and Ms. Hunter. And you never did voluntarily, Ms. Waits, want your money to be used for the political purpose. I mean, you knew, I guess, from the document that went out that day, the RA today, you knew because it clearly stated in there that the NEA Fund for Children and Public Education had those uses that it had, and you didn't want your money to go there, and somebody else put some travel money that you had toward it. So that's that issue, right? Okay. so feeling fairly comfortable that, the law allows for protection against what everybody here seems to want to complain about, let me take it to a broader prospect, Doctor. I think most of us would want a fair political system, and we wouldn't want anybody to be over-advantaged against anybody else. So when you look at the Citizens United case, and you understand the impact there, I think it's Jacob Hacker, a friend from Yale, said in this case, first, people with a lot of money, they had an advantage. They could hire lobbyists. Then they could give a lot more in political contributions than the average citizen or regular family. And now, under Citizens United, they're going to be able to buy attitude, right, and spend all they want. And sometimes their shareholders might even, in fact, be pension funds or other organizations that are populated by people who some of the policies the corporations espouse may work against. Is that fair?
That's absolutely correct. And I have to admit, I'm very concerned about it for the future of our country and for my kids' future.
I mean, look, in fair disclosure, everybody wants to disclose, I was the president of the Chamber of Commerce in my community, but we disassociated ourselves from the United States Chamber of Commerce that we regularly saw working against our interests, always championing tax loopholes and things to favor corporations taking jobs overseas and on and on and on, and not doing things that we really thought in our local communities would be helpful, supporting education, supporting better roads and things of that nature, and always generally saw union members and other people that were working non-management and small businesses have a lot in common on that basis. And I think one thing they have in common is that Citizens United, the way it's crafted right now, could work greatly to their disadvantage.
I believe that's true.
On that. Do you think it would be useful to have a law that allowed for the same kind of protections for shareholders that the law currently allows for union members or non-union members who have to pay an agency fee?
I think it would be very useful. As I said before, I think those to opt out would be very popular with investors. I don't invest in a company because I want them to represent my political views. I invest in a company because I want a secure return in the future. And that's what people expect to get out of investment. So that when the Supreme Court politicized that act through Citizens United, they created a huge problem. They created a problem not only in private relationships where employers set up pensions, but especially in a relationship like mine where the state sets up a pension and requires me to participate in it. Because there you have clear state compulsion for me to participate in what is basically political voice.
Mr. Bowman, would you favor or oppose laws that apply the same protections to shareholders that are available to employees?
Well, I think it's comparing apples to oranges because shareholders can choose not to invest in the company. Union workers have to, as a condition of employment, pay dues to the union. So
that's not true in a right-to-work state, is it?
I'm sorry?
That's not true in a right-to-work state.
It's not true in a right-to-work state.
They can voluntarily opt out.
Yes, they can.
Okay. So if you're a shareholder and you have money in a mutual fund, how likely do you think it is that you know exactly where those funds are being invested and then what that corporation is doing with your money?
Well, I think it's due diligence. They need to find out exactly where, and then they can choose to invest elsewhere.
As I guess you must think Ms. Wade should have done.
I don't know the situation of her.
Yield back.
I thank the gentleman. We now go to the gentleman from Oklahoma, Mr. Langford, for 5 minutes.
Thank you, Mr. Chairman. This is an interesting series of conversation about the agency fees and opting out and such and providing those type of protections. And I understand the statements of we have laws in the books that handle this. Of the individuals that are here, do you think these Beck rights, these opt-out provisions were enough for you in your specific situations? Were you able to opt out and to say, Ms. Waite, you can start and just kind of go across the panel here as well?
I was not able to opt out, and when I asked for the money to be returned, I was refused.
Okay. So these specific opt-out provisions did not work for you?
Right.
Okay. And that, Ms. Carter?
When I made the request, basically I was told that to be a, quote, non-member union person, I still had to pay the equivalent fees equal to the union dues. And then I had to go through this big, long process. It had to be a religious reason that I had to prove that I wanted to divert a certain portion to a nonprofit or a different organization, that the union agreed to allow me to donate or divert that money to.
Okay. So fairly lengthy process to do that, fairly bulky process.
Right. And
you still have to pay the agency
dues. Still have to pay, yeah.
So if you want to just personally donate to somebody else and say, I'm not going to pay the agency dues, I don't want to, don't put any of my money down for political, I want to personally contribute to who I want to contribute to, that's not a possibility. So somewhere in your agency fees was going to be contributions.
Right.
Directed through the union.
And then they want quarterly reports showing me, or that I had to prove to them that that portion that I diverted was going to where they had agreed was an appropriate place for it to go to.
Okay.
As I mentioned before, I believe both Ms. Waits and Ms. Coomer are public employees, and as a result, they would be governed by the law in their states. And actually, the law, and they would have an opt-out there. They wouldn't be eligible for Beck rights, but they would be eligible for some kind of opt-out from the law in their states. And Ms. Coomer, I'm not familiar with Washington's law, but it sounds very interesting where they allow them to opt out, but they have to give to a charity of their choice so as not to encourage people to opt out. In other words, they still have to support, you know, the public weal in some ways. Now, Mr. Bowman.
Wait, hold on. I'm going to let Mr. Bowman answer for Mr.
Well,
Bowman.
Mr. Bowman
hold on.
Is eligible, but he
hold on, sir.
The gentleman controls his own time. Go ahead, Mr. Lankford.
The statement that I'm making is where the Beck rights did they apply, and your statement is no, this is a state issue, so they don't apply on it. I'm trying to determine that. Mr. Bowman, you can answer the question.
For state employees, I'm not eligible for Beck either because I'm a state employee.
I am not a state employee, according to the state of Washington.
Mr. Bowman.
Okay, well, thank you. First of all, I have not exercised my Beck rights because I am trying to effect change while as a member, an active member of the union. But as in my testimony says, there is a lot of fear that goes in with union members by exercising their Beck rights, specifically because they have to resign their union membership first. And when you're on the shop floor and people know that you have exercised your rights, there's harassment, there's persecution, there's ridicule from your fellow workers along with the union officials themselves. Now, I think that alone speaks very highly of making the Beck decision the default position for all union workers up front, and then only those who want to pay over and above can choose to do so.
Right, and there are individuals, yourself included, that want to stay involved in the union. I have some folks in Oklahoma City. In Oklahoma, we're a right-to-work state. We have some fantastic people that are union members that are very engaged, whether they be firefighters or police officers or all kinds of different unions there. I have no issue with that. And for the collective bargaining and for the organization and for what they want to be able to do to be able to negotiate together, that is not the issue. The issue comes down to the accountability side of it. An example of this would be the ICAP audits, to where audits are done by the federal government of going down to the community side, the local side. But as of 2012, according to the Obama administration, they're going to do 0 audits for the international unions. Does that bother anyone that the new decision is if they're a small union in a local area, they're going to have transparency, but the larger the union is, the less transparency that they're going to have?
I think that's incredible. I had not heard that, and I find it quite upsetting.
Well, this is from the Office of Labor Management Standards, just to say that for FY 2012, the quote there is, if you can get a chance to read it, there will be 0 ICAP audits. So that office has been defunded and put down on it. So the issue here is not whether you want to be a union or not be a union. That should be completely voluntary, but it should also be transparent. Everything should be open. Everyone should be held to the same account, and there should be the opportunity for a member of a union to also be engaged, to not be excluded from that. With that, I'd yield back.
I thank the gentleman. We now go to the gentleman from Connecticut, Mr. Murphy, for 5 minutes.
Thank you very much, Mr. Chairman. In Mr. Bowman's testimony, he suggests that the political speech of unions is essentially equated to what he calls an offensive and radical left-wing political action. And we're used to hyperbole here, but this is certainly parroted by much of the talk we hear about what unions are doing in the political context today. And I think it stands behind a lot of the attacks we've seen on labor unions, this idea that labor unions are speaking in some radical way. And Mr. Kucinich did a little bit of this, but I do think it's important to, in some detailed way, go back over the record of the political action of labor. Now, I won't claim that labor has been responsible for every great social or workplace safety advancement in this nation, but they've been a pretty integral part. You know, there was a time when there were little kids working in factories throughout this country. There was a time when the average adult was working 61 hours a week. And in large part because of union political action, we passed the Fair Labor Standards Act. There was a time in this country where workers were getting paid cents on the hour, weren't getting paid enough to put a roof over their head or food
on the table. And in large part because of labor political action, we got the minimum wage. There was a time when if you got injured at work, you'd lose your job, and the only way that you could recover any damages or any lost wages was by suing your employer and racking up expensive legal fees. In part because of labor political action, we got workers' compensation law. And a lot of people say, well, that's all prior history. You know, that's all about what happened 50 years ago, 75 years ago. Well, just about a decade ago, it wasn't foreign that if you had a newborn child or a sick relative and you had to take some time off work, you couldn't get your job back. And in large part because of labor political action, we got the Family and Medical Leave Act. You can disagree with all of those things. You can say that we shouldn't have a minimum wage, we shouldn't have the Family and Medical Leave Act, but I don't think that any of those acts are considered radical today. I don't think that much of what labor is advocating for is considered extreme today. And I guess it leads me to a few simple questions to the professor. We've heard a lot about the free rider phenomenon in the sense that if you're not paying dues in a right-to-work state, you still get the benefit of the contract that the labor union negotiated. And I think that's a real problem. But what we don't talk a lot about is the free rider syndrome, in which workers who aren't paying dues to a labor union also get the benefit of all of the social change, the very non-extreme advocacy that has led to these acts. And so, Professor, my question is this. Do non-paying dues members in this country get the protections afforded to them under the Fair Labor Standards Act?
Yes, they do.
Do non-dues paying members in this country get the protections afforded to them by a federal minimum wage?
Yes.
How about the workers' compensation law?
Yes.
And the Family and Medical Leave Act?
Yes.
Listen, we can disagree about the particular actions that labor unions engage in the political context. That's why we have the protections that allow individual workers to opt out. And I think folks on our side have done a pretty good job of explaining those protections. But the notion that there is some radical agenda that labor is perpetuating in the halls of Congress or in state legislatures, I don't think is backed up by the facts. And I think the idea that going back through the history of social change in this country, that we haven't been benefited, workers haven't been benefited, whether you are a dues-paying member of a union or not, by fair labor standards, minimum wage, workers' compensation, medical and family leave, and dozens of other pieces of legislation, is a rewrite of what's actually been happening when labor unions come and advocate on behalf of their members in the United States Congress. With that, I yield back my time.
The gentleman yields back. With that, we go to the gentleman from North Carolina, Mr. McHenry, for 5 minutes.
I thank the Chairman. And I know this is not about a question of right-to-work laws in individual states. This hearing is not about that. But I want to thank my colleagues on the other side of the aisle for their advocacy against right-to-work laws in their respective states. I want to thank them for that because in North Carolina, as a right-to-work state, it helps us economically. I certainly appreciate their willingness to advocate for closed shops for unions. I certainly appreciate their willingness to advocate for laws that drive up the cost of doing business in their respective states, and I certainly appreciate their advocacy for that. So I just want to take a moment to sincerely thank them, not just on my behalf, but on behalf of the folks in Western North Carolina that want more jobs and want more economic growth. Now, we did hear a lot of testimony about labor practices in the 1920s. We had a lot of questions and comments about that. And certainly unions had their place and they had their time, but we also have international competitiveness issues. And we have unions that are negotiating to keep their dues and to keep their income stream going, while at the same time cutting employee cutting employees, cutting pensions, raising the cost of health care for their union members. So their advocacy is, let's just say they're trying to keep their money flowing to them. But that's neither here nor there. So one of my colleagues said that basically the unions passed the hat right? They pass the hat to get union membership. Mr. Bowman, do you put your dues in a hat, or is it deducted from your paycheck?
It is deducted from my paycheck.
Okay. Ms. Comer?
It's deducted from the paycheck.
It's deducted from my paycheck.
Okay. Okay. Now, just want to be clear about that. Now, is there any question about how your dues are divvied up? Do you have a vote on that, Ms. Waite?
No, sir, we do not.
No.
Ms. Comer?
No, sir.
All right. So this is interesting to me. Ms. Comer, I appreciate your testimony and for making the trip here. How old's your daughter?
21.
21. Excellent. So in your testimony, you outline the fact that you basically are being paid by the state to be, or you're paid by the state to take care of your daughter.
Right.
If you didn't do that, some other individual would do that.
Would need to do that, yes.
Okay, would need to do that. So you got a notice when this happened. I mean, this is a state regulation, a state law, and the construct of how you're taking care of your daughter.
Actually, she got the notice.
Oh, she got the notice. Okay.
That her family provider could no longer provide care for her through an agency, that they had to transfer over to the unionized IP system if they wanted to continue providing care.
Okay. And so could you have said, no, thank you, I don't want to be a member of the union?
I could have refused to sign up as an individual provider, yes, and then I would not have been able to continue providing for her Medicaid personal care.
So you would not be able to take care of your daughter?
Right.
That's a horrible choice set, and I'm sorry.
Exactly. And I don't know a parent who made the decision not to make that move because of that very reason.
So not only do you not have a choice about being a member of the union, you don't have a choice about where those dues even go.
Correct.
Okay. This is really the crux of this discussion today. You're being forced, money is being taken out of your pocket. Now, there's a comparison to corporations. Now, with a corporation, if you're an investor, you can simply not invest, right? I guess conceptually, you don't have to take care of your daughter. I mean,
suppose.
So, but it's an illegitimate choice set here.
Right.
For a comparison between investing in a corporation and an individual providing care for their child. Now, I just wanted to make that point here. My colleague from South Carolina always asks great questions. I know I only have a few additional seconds, but
would the gentleman yield?
I'd be happy to yield to the chairman.
Just one question. Did you get a pay increase when you were involuntarily converted in status and put into the union?
No, actually,
So did you get a pay decrease by having the same amount of money but less of it net?
Right. I got a pay decrease, decreased benefits, and I was no longer able to cover my children, my dependents, on the health insurance coverage.
So because of the union's political activism, they were able to take you from being out of the union, receiving X dollars to take care of your adult child, to put you into a union where you got less net dollars to do that service, but they got dues. That was the only change you saw.
Correct, other than some of the decreases in benefits and not being able to cover my other children dependent. That they have no dependent coverage, which I had before when I was not a union member.
If I wasn't a member of Congress, I'd say you got you-know-what out of this, but I'm not going to go there. I thank the gentleman for yielding. I yield back. And the gentleman's time is now expired. We now go to the former chairman of the full committee, the Honorable Adolphus Towns, for his insightful questions.
Thank you very much, Mr. Chairman. You sound like my mother. Let me.
God bless her for bringing you to us.
Thank you very much, Mr. Chairman. Let me begin by, first of all, I have a statement for the record, ask unanimous consent, of Mr. Robert Hahn, member of Local 514 of Wisconsin. I'd like to ask for permission to insert it in the record.
Without objection, so ordered.
Thank you very much, Mr. Chairman. Let me say, just yesterday, less than 24 hours ago, this committee conducted a business meeting in which our objective was to take money out of the pockets of federal workers to reduce the national deficit. There was no, and let me emphasize, no efforts whatsoever to get corporations to shoulder the same burden. Today, despite its title, this hearing again focuses on the worker, except that now we are looking to put further restrictions on the right of those workers who are unionized and who are working hard to live the American dream. All over this country, and of course right here in the Capitol, we are witnessing a sustained campaign against American workers and the unions who represent them. These campaigns are aimed at silencing the voices of unions and give more power to the big corporations over things like reasonable wages and benefits and safe working conditions. Let me begin by saying to you, Mr. Bowman, and of course, Ms. Waits, do you feel there's an attack on the unions? Do you feel there's an attack on unions?
No, sir. I don't feel that this is an attack on unions.
But you don't feel there's an attack on union in general either, huh?
I think we're more in terms of unions making political contributions without any consult with their membership.
How about you, Mr. Bowman?
I agree completely with what you're saying. This is not an attack on unions on collective bargaining. This is not an attack on unions' collective bargaining rights at all. It's a meeting to hear discussion on unions using our regular dues for political spending.
Professor, you want to say something?
Well, living in one of the frontline states, I'd have to say there is a systematic attack on unions. My collective bargaining rates were taken away unilaterally by the governor of Indiana in 2006. And then the Republicans in the state proceeded to limit collective bargaining rights for teachers, who are the only remaining public sector employees who have any collective bargaining rights at all. Once they were done with that, they moved on to right-to-work legislation because that was the way they could weaken private sector unions. And this is all part, I think, of a political act on their part. They are trying to undermine people who have been traditional political opponents of theirs and supporters of the Democratic Party. So it does not surprise me at all that most union campaign contributions go to Democratic candidates. In Indiana, I can guarantee you the unions are very upset with the Republicans because they have so tried to undermine union power. And in fact, there is an organization in Indiana called the Lunch Pail Republicans, who are conservative union members who generally do not support Democratic candidates, but they actively campaigned against the governor and his position and right to work, and they are threatening to field candidates against all the Republicans who voted for right to work. And it looks like they're going to be fairly effective at it. So there are conservative union activists out there who are very upset with the attack that's been made on unions.
Well, you know, let me just say that I think you need to be careful. You know, because when you look at the improvements that have been made in the workplace, that a lot of them came about because of unions, even in situations where people were not even unionized, that based on the activity of the union that made the workplace safe. And I think that we need to sort of analyze that and look at it. You know, even if there's one thing that you dislike, let's look at the 99 you should like. And of course, I can remember when people would work 60, 65 hours a week without any overtime. I'm old enough to remember that. And of course, they just would pay by the hour, and that was it, and paid very little. So, you know, I look at what's happening in corporate America, and I think that we need to really be careful. You know, and I think some of my colleagues on the other side, on this side, mentioned the fact that in terms of what's going on with corporate America. So I say to you, Mr. Bowman and Ms. Comer and Ms. Waits, you need to be careful. You need to be careful, because if not, you might come back a few years from now and start talking about how life is so miserable as a result of you not having that protection. I yield back.
Gentleman yields back. I want to thank all our witnesses for being here today. This was the first of a series of hearings. As a result, you probably went through some of the growing pains that come with opening up a new subject. I'd like to thank all four of you. I think you presented your positions extremely well. Certainly, you can tell that we are divided here on the dais. I think that the important thing here today is that the issues you brought before us and any additional comments you may want to bring to the committee in the next, I would ask, try to do it in the next few days, we will include in the record. If there's no further comments by any of the panelists, I would ask unanimous consent that the committee majority staff report be placed in the record at this time. Without objection, so ordered. And again, thank you very much. You're an important part of democracy, all of you. This is a process in which we're going to look as a committee at the law as it is changed under the Citizens United decision to try to find the right way to get openness and transparency and ultimately come to grips with the fact that the law is what the Supreme Court says it is. I want to thank you. We stand adjourned. Not so bad, huh? Yes. Hi.